Welcome back. Today we're diving into a courtroom saga that starts with something as small as a complaint over cold food and ends in a high-stakes battle for a man's freedom. We're looking at Reginald Tyrone Green, a man who seems to be his own worst enemy. Pay attention to how the judge reacts here, because in this courtroom, excuses are the one thing not on the menu.
Well, all of this really started because you said your food was cold and you want somebody to give you refund for cold food and you didn't return the food. He's released and he immediately picks up with another theft case. That's in May.
Because I'm not happy. But, these kids,
Mhm.
no one wants to see them.
So what's going on? Why can't you come to a resolution with this individual?
No,
and get an
I
understanding?
did. I did.
Stop talking.
I tried to, and everybody is getting upset with me because I'm asking questions. Like I keep just being told to do stuff, and I'm not. This last time, I just came back into the breakout room with him.
Did you understand you're charged with unauthorized use of a vehicle? That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, sure.
All right. After reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court would defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
So this is your parents' vehicle?
Yes, ma'am.
Why are you doing this to your parents?
So me and my stepmom had a disagreement on a payment, and my dad was unaware that she filed unauthorized use.
Well, all of this really started because you said your food was cold and you want somebody to give you refund for cold food and you didn't return the food.
Did you catch that? The judge just gave some of the best life advice you'll ever hear in a courtroom. Do not do business with family. Legally, when you use a vehicle without consent, even if it's your parents', it's a state jail felony. Reginald thinks this is a family dispute. The law sees it as unauthorized use of a motor vehicle. He's getting a gift with deferred adjudication, which means if he stays clean, he avoids a final conviction. But as we're about to see, Reginald is not good at staying clean.
I called the cops and asked them was it unauthorized, so I turned myself in.
So here's the thing. You want a vehicle, get your own vehicle.
Yes, ma'am.
Do not involve yourself in business transactions with family or friends. If you do, it usually doesn't turn out well.
Yes, ma'am.
Do you have a driver's license?
Yes, ma'am.
You need to present that to probation. If you don't, you're not allowed to drive.
Yes, ma'am.
When's the last time you had employment?
I'm employed now.
Doing what?
I'm a supervisor at DirecTV.
Oh, okay. Oh, everybody's said because they're talking about how the bills keep rising for that. But okay. The court is going to take in consideration County Court Cause number 709056, 709057, 2 years deferred adjudication, regular reporting by Zoom or in person, regular random UAs, proof of employment within 30 days, no employment as a home health care provider or with minors, anger management, field visits 1 time per month for 2 months, no driving until valid license is presented to probation, 80 hours of community service restitution. Do you have any children?
Yes.
Ages?
3, 12, and 10.
Do you see them?
Yes, every week.
All right. Parenting classes. Once he completes parenting classes, the community service hours will be deemed satisfied. Probation. Is there anything else? Is there anything else you need to be successful? All right. Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes, sir.
Because it's a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, sir.
All right. Know better, do better. Okay.
Yes, ma'am.
All right. Who's here on Jessica Alcazar? Yes.
Let me check.
Where are we on discovery?
Judge, we're still going through discovery, but we did receive a plea offer from the state today that was reasonable. I just need time to discuss with my client and go over discovery with her, and I think we'll come to an agreement next setting.
All right, Ms. Ferguson, on Alcazar, I hear Mr. Green. I think of Matthew McConaughey in The Lincoln Lawyer.
Never seen it.
Okay. Have you at least read the books? Oh my gosh. Well, there's a scene in it where, the defense attorney is asking for a continuance because they have a missing witness. And the missing witness is Mr. Green. So now you know what I mean, right?
I got it. Every time I hear Mr. and then color, I think of Reservoir Dogs.
Oh, yeah. Oh, yes. All right. Are you all still having your contested?
No, Your Honor, we've reached an agreement, I believe.
All right. The court is calling 2023 CR 10024 State versus Reginald Tyrone Green. Can I have parties announced?
Those for the state.
Andres Camping for Mr. Green.
And are you Reginald Tyrone Green?
Yes.
Did you review the documents entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision and First Amendment Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes.
Are you the same Reginald Tyrone Green who was placed on deferred adjudication in 2023 CR 10024 for the offense of unauthorized use of a vehicle on April 16, 2025?
And he blew it. Just weeks after being placed on probation, Reginald is back. But this time, the stakes have skyrocketed. He's accused of a new theft. In the legal world, this is a motion to adjudicate. The judge is no longer looking at him as a person who made a mistake. She's looking at him as a person who refused a second chance. Look at the shift in the room's energy. The grace period is officially over.
For a period of 2 years. Is that you?
Yes, sure.
All right, state.
Violated condition number 1 on or about the 21st day of May 2025 in Bexar County, Texas. The defendant, Reginald Tyrone Green, committed the offense of theft in violation of condition number 1.
How do you plead to that? True or not true?
True.
State will waive all others.
Any objection?
No objections, Your Honor.
All right. Did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty, and sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, sure.
Knowing that, do you still wish to plead true to violation of condition number 1? Court will find violation of condition number 1 true. Is there a proposed agreement?
Yes, Your Honor, the proposed agreement is to grant state's motion to revoke sentence to 180 days in the state jail facility and take into consideration cause number 2025 CC 007955.
All right. And that cause number, what is that cause number?
That is the theft considered pleasure too.
All right. And then as a part of your previous plea bargain agreement, the court was asked to take in consideration county court cause number 70, if everybody could write this down, 709056 and 709057. And what were those cause numbers? The offenses.
I'll be close to the one that we're
Yeah.
taking in 007955 and then 707056.
All right. I'll see if I can look it up. Yes.
So cause number 709056 is a criminal trespass, and the other is a resisting arrest.
All right. So what has he done on probation other than pick up another theft case? Has he completed anything?
Your Honor, I don't believe he has been out on bond long enough to complete anything. It's my understanding that Mr. Green has been struggling with some mental health issues and is ready to accept any and all help that the state will offer. The underlying offense, I believe, is a unauthorized use of a motor vehicle that stems from a confusion with his parents. His father is here, present, and is standing behind and supporting Mr. Green. I am not, I do not believe that Mr. Green has successfully completed any of the other conditions of his supervision, but the desire is to pay his debt to society and then to relocate up to Texarkana with his family, and then be with his support network up there so they could help assist him in getting on track with everything.
All right. What I can tell you both is I don't think 180 days is appropriate. He was on probation for unauthorized use of a vehicle.
Yes, sir.
Which is sort of close to being a theft. Sometimes the state will file it as a theft of a vehicle. Sometimes they will file it as just unauthorized use. And then while he's on probation, he's released and he immediately picks up with another theft case. That's in May.
Yes, sir. The theft cases, I believe, are shoplifting, not a forceful dispossession. And from what I understand, there may have been some other factors at work, but from our perspective, the decision to request that the state offer Mr. Green the ability to serve some time on their revocation was something that was agreed upon by all parties to help facilitate Mr. Green's getting past all of these incidents. I do believe he has a number of days in custody as credit that we would ask the court to attribute to him. But
he has an unauthorized use that he's on probation for April 16, 2025. He doesn't do anything on probation. The only thing he does is pick up another theft case on May 21st, 2025. I'm assuming he gets arrested at some point in time for that, gets released, and then in June, he's alleged to have committed another theft of 2025. I just don't think 180 days is appropriate for him because he hasn't done anything on probation other than pick up new offenses. Y'all are dimming the lights. All right, so this is what the court is going to do. The court is finding you guilty, finding, as previously stated, found violation of condition number 1 true. The court is revoking. The court is taking in consideration 2025 CC 007955. The court will sentence you to 14 months in the state jail facility, give you credit for any time served, and the court will request the
14 months in state jail. That is a massive jump from the 180 days the defense was hoping for. The judge is stacking his record, refusing to ignore that he did absolutely nothing to improve while on probation. What do you think? Is 14 months fair for someone who keeps picking up small theft charges, or should the court take his mental health struggles more into account? Let me know in the comments.
Therapeutic community.
Your Honor, if the court would entertain a little bit of testimony as to the underlying, if that might
sure.
have the court can reconsider in its assessment. We would like to call Reginald Green, Senior, to testify.
Hello. Could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Nothing but the truth.
All right, you can lower your hand, state your name for the record.
Reginald Green.
All right, yes.
Mr. Green, who are you in relation to Reginald Tyrone Green?
That's my son.
Okay. And are you familiar with the underlying charges of the unauthorized use of a motor vehicle?
Yes, that was our vehicle that we gave to him. He was going through a breakdown at the time. He brought the car to get the what's called miles to get some work done on it. Came up to be $1,000. With his breakdown, he just figured he could go get the car, take the car. The people saw his state. They didn't press charges. We paid the $1,000, but my wife decided to take the car back because of his mental state.
Okay, so let me stop you right there. So here's the thing. Once somebody has been placed on probation, they're placed on probation. It would probably be best for you if you are now saying that he is innocent of these charges, didn't commit these charges, that's something for the public integrity unit of the district attorney's office. But I cannot legally go back and undo the fact that he's on probation.
He mentioned it.
Yeah.
I understood that.
So here's my thing. Why, if you know, why is your son, he's on probation for a theft case, and he, you know, the unauthorized use, and he continues to pick up more theft cases?
Because he was going through a mental situation. We committed him into the hospital because.
And when was he committed into the hospital?
I can't recall right now, but it is record that he was there. But the thing is with Reginald is with his kids. His kids are more important to him. His wife used his kids to keep him from seeing it. He gets, because he's not scared, he gets upset. So that's why she puts him on where he can't come. Then, so he don't know how to handle that. So he do things like he really don't have a place to live. So when he was stealing, he was just trying to get it wrong. I've been trying to get it to Texas County because I know I can help him. But you know, leave his kids. Mm-hmm. No one wants to see their child. If you knew Reginald, you would know. He's a person that gives insurance. He's a hard worker. It's a long story. He don't just get here. This was a long process. That trying to do the right thing instead of hitting the wall. He got arrested this time. He was on his feet. By being on his feet and get arrested, he loses his job. So now he starts over. Now he has no, because the main thing is for him is paying his child. His father was taking his majority of his whole check because he had 3 children. He loved his children. He had a spot on that. But when he lost his job, he had nowhere to live. So again, he refereed whatever hustle he could get to get a room, just a roof over his head. And that's what he was supposed to.
All right.
And so, Your Honor, I offer this testimony.
Just 1 second.
My apologies.
Do you have any questions? All right. Thank you so much for letting me know about your son.
Your Honor, I offer this testimony so that the court could maybe reconsider its decision in its sentencing, knowing that Mr. Green is going to be getting the help that his family wants to offer, and that they would love to have him come up there to Texarkana, but they do understand that he needs to be admonished and punished and has to take some responsibility. And they're not trying to obfuscate that, and they're not asking the court to ignore that. They're just asking that if the court would to follow the plea agreement, that they believe that they would be able to be in a position to help Mr. Green once he is done with his sentence and can be back with his family in Texarkana, hopefully to get him back on his feet and assist him in any other way possible, as not just being his family in present, but also being someone that he can rely on and not have to.
Do you have proof of his mental health issues?
I do not on me at this time.
All right. So this is what the court is going to do. The court sentence will remain to guilty, revoked, taking consideration 2025 CC 007955. 14 months in the state jail facility, give you credit for any time served in the therapeutic community. If your counsel brings proof to the court of mental health issues, proof to the court from your family of some sort of plan, then the court will reconsider if the state has no objections. And I say if the state has no objections because there truly is no legal motion that's a motion to reconsider. Once the court enters a legal sentence, that legal sentence stands. So the state would have to agree.
This is a crucial legal moment. The judge just told the defense that she cannot legally reconsider a sentence once it's entered. However, she drops a hint about shock probation. This is a Hail Mary move where a defendant serves a short time in jail, the shock, and is then brought back to be placed on probation. It's Reginald's last hope, but it's a long shot. Now, we shift to a new case, Malik Beer, and the drama only intensifies.
To allow the court to reconsider. Do you understand?
Yes, please.
All right. Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and sign it? All right. You have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are in deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over that, you'll need to speak to an attorney. Do you understand?
Yes.
All right. Thank you. And when do you anticipate having that information?
I will get it to the state if I can before the end of the week.
All right, then you need to speak with Ms. Ferguson about putting it on the docket for a motion to reconsider.
Yes, Your Honor. Thank
Thank
very
you.
much.
You're here on a motion to reconsider sentence?
That's correct, Your Honor. The court
Yeah.
may recall a few weeks ago, he was here on a revocation proceeding. He pled true. There was an agreement with the state for a recommended sentence on his revocation of 6 months in the state jail facility.
Mhm.
Obviously, that's not binding on the court, and the court's view of the circumstances at the time was such that I think the court assessed a 14-month sentence, if I'm not
Yes.
mistaken. You may recall, Your Honor, that the defendant's father was here and provided testimony about his mental health issues and some of the circumstances regarding the underlying offense. It's an unauthorized use of a motor vehicle, which involved his parents' car. In talking to the parents, it's not something they were excited about pursuing, but we didn't represent him on the underlying charge, so here we are. The situation arose that after the father's testimony, I think the court was inclined to reconsider if there was some documentation that would have supported or maybe corroborate the mental health circumstances that he had been encountering in his life. And also, I think there was submission at the time from probation that he had not accomplished anything while he was on probation. What we have tendered to the court for purposes of reconsideration are medical records we were able to obtain from the University Health System. You may recall his parents had him involuntarily committed at one point. These records we've obtained kind of, I think, demonstrate to the court some of what Mr. Green has been dealing with. On page 2 of the records, I think of the medical records, page 1 is just the cover sheet they sent us, but page 2 has an assessment per EMR of bipolar 1 manic with psychotic features. The other pages we have selected for the court's review kind of corroborate that, go into a little more detail about his bipolar. And really what happened, I think, in history was his circumstances domestically were kind of on the downside. His wife left him. He took the kids. He went into a pretty deep state of depression and precipitated all this stuff. He ended up losing his job, living on the street, picking up shoplifting cases, and here we are. But to his credit, he didn't just completely go off the deep end. He got involved in a church, a ministry here. We have included as an attachment to today's motion, a letter from the pastor of that ministry, a Blaze ministry here in San Antonio. And she corroborates that he had been very, very active in that church once he joined it. He, not just in the ministry program on a volunteer basis, but he also helped a lot just in the physical plant, the maintenance, just the heavy lifting and toting that is associated with maintaining a property. And so I think his heart has been in the right place. His mind has been anywhere but where it should be. And under the circumstances, his father and mother would love for him at some point when this is behind him to relocate to where they're at in Texarkana. They will provide a home for him, get him back on his feet. He's got a job prospect there that is very promising. And his biggest concern right now is being able to resume some type of productive life, be able to pay child support to his children, and kind of renew and reconstruct his life with his children. And with those things in mind, we're hoping that the court would reconsider the agreed recommendation from the state. It obviously the court's judgment is what we abide by, and we live with that, and we're grateful for your reconsideration of this matter. But the recommendation from the state wasn't haphazardly arrived at. I think we discussed his whole situation, the underlying offense, the circumstances of his living at the time, mental issues. And so we felt like it was appropriate, and we're hoping the court would reconsider the 14-month sentence that was assessed.
State?
Your Honor, based on what is said, I will echo defense counsel's sentiment that these items were discussed with me prior to us bringing that agreement to the court. However, I would just defer to the court's decision on this
All right.
matter.
Well, what I can tell parties is that once the court enters a legal sentence, the motion for reconsideration, that's really not a legal motion. His only options, and I'm not your attorney, I'm not trying to tell your attorneys what to do. His only option is a shock probation, because the court legally cannot reconsider a legal sentence. So the motion to reconsider will be denied.
All right. Okay. Even though we're within the 30-day period, Your Honor, for plenary jurisdiction?
No.
For what it's worth, Your Honor, if I may, it was at the court's recommendation that, and the court did announce that there's not a legal means or method or vehicle to do this, but that the court would consider the new information in that format, and which is why we had filed it at the request of the.
We can go off the record. My suggestion is a motion for shock probation.
Got it. Understood.
Okay. Thank you very much. Thanks, Judge.
All right.
Thank you.
And now, with regards to shock probation, depending on how long he's been in jail, the court will consider that.
Thank you.
All right. You're welcome.
We'll pick up the conversation.
Proceed, Judge.
All right. According to the plea bargain agreement, punishment is to be assessed at 10 years in the prison. The state is opposing his application, and they're taking in consideration 2018 CR 10109A, and there's restitution to Chase Bank and Circle K under 2018 CR 10109A. All right. Are there any witnesses from the state?
Not from the state.
Defense.
Yes, Judge, but if I could just point out for the court, I think it's page 3. There's a error in the calculation of restitution. I think it's like 27,000 on page 3, and it's 2,700 on the last couple of pages. So I just wanted to bring that to the court's attention.
All right. Thank you.
I wanted there to be the accurate number.
Oh, yeah. I don't believe Circle K has 27,000.
Yeah, I
Okay.
think so. I just wanted to let the court know.
Thank you.
Judge, we would call Talisa Holmes.
Talisa Holmes. All right. Could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right. You can lower your hand. State your name for the record.
Talisa Holmes.
All right.
You can spell your name, Miss Holmes. Is that your full name?
TELISA, last name HOLMES.
And could you tell the court what your relationship is to Mr. Breuer?
I'm his mother.
And Ms. Holmes, what do you do for a living?
I am military retired, Army retired, and so now I work a daiquiri shop.
And you're aware of what Malik is charged with, and you are aware of the decision that the court is facing today, which is whether to send him to prison or to put him on some kind of a probationary term. Okay. And what would you like to tell the court as to why Malik should receive probation instead of going to prison?
Sorry.
Okay, take your time.
Counsel.
Yes, thank you, Judge.
You're welcome.
You know, as a parent, your kids are your life. You do your best, to make right decisions for them so that they can make correct decisions in their life. Not saying that they'll always make the correct decision, but I think that what the charges are, I think that was an impulse thing for him. He was in the wrong crowd.
he was young, he's still young. And I don't want his whole life to be in incarceration. He'll never get to understand how to adult in life, the responsibilities of being an adult and being somebody that can add to society if he's in incarceration so early in life. He's not gotten in any trouble again. And I just, I haven't been able to be in contact.
And Ms. Holmes, let me ask you, would he be living with you if he were granted probation?
He'd be living with me.
Right. And are you available and willing to support him in whatever conditions that the court may assess to his probation?
Yes, ma'am.
Okay. And then that would include him getting to a probation officer and reporting, getting some outpatient mental health treatment, anything like that. Are you willing to help him get where he needs to go and do what he needs to do?
Anything that the judge deems as would be helpful for him to stay out of walls where he can't.
And do you feel like you have sufficient control over him in a situation where, in other words, he would abide by your house rules and do what he needs to do?
Yes, ma'am.
Okay. Is there anything else that you wanted to let the court know?
Just, I can only plead as a parent for behalf of my child for the court to do what's in his best interest. And that would be for him to be with his family. It'll help his morale. It'll help our morale. And, he's got a young one also. He's got a baby that he hasn't met. So, things like that help to redirect any negative behaviors from an individual. I can't say the same thing if we were to be apart for longer.
And at the time of this offense, when it occurred, he was 17, is that correct? And he's 21 now. And so he's gotten married and had a child in that time?
Yes, ma'am.
We'll pass the witness, Judge.
State.
May I, Your Honor?
Yes.
Thank you. Ma'am, was your son living with you during this time of this offense back in 2018?
That specific time frame, no, sir.
He wasn't?
No, sir.
And he was only 17 years old?
Yes, sir.
Why was he not living with you?
Because just like any child, he wanted to live independently.
Okay, so independently, he went out and committed the robbery. Is that correct?
I think that, no.
Okay. And then when and are you aware that he went to Bell County and was arrested there for 3 different charges in 2022?
I have not been in contact, so no, that's not aware.
So you haven't been in contact with your son in 2022?
3 years.
How many?
Years. 3, 4 years.
So if he is given either deferred or probation, is he going to live with you?
He's going to live with me, yes, sir.
But you haven't been in contact with him for how many years?
3 years.
Okay. Thank you. No further questions.
We have nothing further.
I have a question.
Yes, ma'am.
When you say that you haven't had contact with him for 3 years, is that you all have not talked on the phone? There have been no letters written. You haven't seen him for 3 years?
So I've been writing while he's been incarcerated here. I haven't gotten anything back.
But I mean, has he been incarcerated for 3 years?
Sure.
No, there has been a lag when he was charged with this offense, not in custody. And I believe there's a farm forfeiture on file, and then he was rearrested.
All right. So I'm trying to figure out, why have you not had any contact with him?
I don't think that. So I was going through my own military, issues and things, and I don't think that my son wanted me to be more involved in what he had to go through.
No. I'm not talking about the jail instance. I'm not talking about him being charged with this. I'm just talking in general. So is there a reason you haven't had any contact with him?
No, all
right, just a moment. So the line that's here, there's an inmate right there. So I'm sorry, but you all are going to have to wait because it makes it easier for the deputy. Yes.
I can't say for, 100% why, but we just haven't been in contact because I also had my own pending felony type of thing going on at the time.
All right, what pending felony type of thing?
So I had a hindering apprehension a long time ago, like 2019.
I'm sorry, had what?
2019, hindering
Apprehension. Okay. And where's his father?
Never was in the picture.
Okay. All right. Thank you. Any other questions?
No, ma'am.
State any other questions?
No, nothing.
All right. Thank you so much for coming in.
Wait for it. Malik just told the judge he's a changed man and hasn't had any new charges. But the prosecutor was ready. He brings up a 2022 arrest for marijuana, evading, and failure to ID. The golden rule of the courtroom: never lie to a judge who has your file in front of them. Malik's second chance plea just hit a brick wall of cold, hard facts. We'll see if his mother's testimony can save him, or if his own words just sealed his fate.
Thank you, ma'am.
Not that it's any excuse at all, but at the time of the crime, I was a 17-year-old knucklehead and drug addict. These past few years, I've grown to fix my bad habits, and I also haven't caught any new outstanding charges. I also don't have any prior outstanding criminal history. I just really need a second chance at life. I just had my first child, who will be 9 months this month, and I want an opportunity to be there for him and my fiance. So if you could find it in your heart to grant me probation, I can promise you 100% that you won't see me again. I just need an opportunity to prove myself. I didn't want to bring my mother into more of being in the way, especially if there was any possibility of her getting any criminal charges brought up against her to mess up further what I had already damaged between going on with my little sister.
This individual was just an acquaintance of yours, meaning that you've only met him a few times and you just hung out with him?
Correct.
So you decided to go in to the Circle K and commit a robbery with him?
No. And actually, that whole day was, I only remember certain parts because I would black out occasionally.
Blackout, but you were blacking out because you're on Xanax, right?
Correct.
And you're also drinking and smoking, right?
Right.
Okay. I mean, that's what you stated in this PSI.
Yes, sir. But I just wanted to also be known that I haven't done any of those drugs since I've been incarcerated the first time for those charges.
But you just got picked up in Bell County of 2022 in March for possession of marijuana. Is that right?
Correct.
And evading arrest and also failure to ID.
Correct.
So you just told the judge, since you got these charges, the initial robbery, you didn't smoke weed or anything like that?
No, sir. I
said had it in your possession.
I said I haven't been able to. The drugs that make you black out, weed doesn't make you black out. But I was smoking because I have anxiety, PTSD, bipolar depression. So I was self-medicating. That's what I said when I was self-medicating instead of taking a prescription because I'm prescribed.
Have you been to a doctor?
Yes, sir.
And diagnosed with all this?
Yes.
When's the last time you went to a doctor?
I'm not sure.
Okay. Thank you. No further questions, John.
Malik, is there anything else that you would like to tell the court? This is your chance.
No, Mom, I just want you to know that, like I said, you will never see me again if you grant me probation because I've changed, I've developed, and I definitely have a child that I don't want to follow the same footsteps as me. I didn't have my father. It's not an excuse at all, but I don't want him to lean towards seeking out other attention from other people because there's not enough love, or if you feel that there's not enough love for you at the house to accept that. I promise you I'll change, John. That's all
Right. See, these are epiphanies that people should have when they're in the free world. I guarantee you, I could be wrong. I don't think I am. I guarantee you that your attorney doesn't have criminal charges pending. And everybody else, the people at Chase, the people at Circle K, they're just trying to do their job. I don't know anybody who, well, there may be some people who 100% want to work the night shift at Circle K or something. Usually they don't. In my lifetime, I've had to work the graveyard shift. And the graveyard shift is one of the worst shifts unless you get your body prepared for it, because no matter how much sleep you get in the day, When 2 a.m. hits, your body is saying, why are we up working? We should be asleep. So the people who are working at Circle K, maybe they love that job, or maybe they're saying, you know what? I need money. I got bills to pay. This is the job that's available for me. I'm going to do it. Everybody in this world, even in this courtroom, everybody's doing their job. Maybe they expect that they should be retired. I thought I was going to be retired at 21. Here I am, 22 years old and still not retired, right? Okay, why is that?
Let the record reflect it.
Yeah.
Who slapped out loud?
Yeah. But it's people just trying to do their job. So this is what I'm going to do. I'm going to find him guilty. I'm going to sentence him to 5 years in the prison. I'll retain jurisdiction, give him credit for any time served, take in consideration 2018 CR 10109A. There's to be restitution to Chase Bank of $2,701. I didn't have in the PSI report a restitution for Circle K. Here's the thing. Your attorney will explain what I meant when I said I will retain jurisdiction. The other thing, you are young. Sometimes people think things happen and it's the end of their life, the end of the world. It is not. You still can pick yourself up and do better. Everything that you told me, I listened to. Everything that your mom said and the proffer from your attorney that your sister said, I listened to. And I think every attorney will tell you that I do take in consideration some of the life choices that you may not be in control of when I sentence people. Because sometimes you get the parents you get. Your parents come with issues. Like right now, your child has a parent who's going to come with him with issues. And no children are allowed, at least I don't know of any children who are allowed to look down and say, well, I want these two parents. You just get the parents you get. But regardless of what happens in your life, at some point, you're responsible for your own actions. It's nobody's fault but your own. When people come to me and they say they're running with the wrong crowd, if that other person were in front of me, they'd say they're running with the wrong crowd, and I'll ask who it is and they'll say it's you. So don't be a part of wrong crowds. You understand? All right. Good luck to you. Thank you.
Thank you, Judge.
I'm here.
Ms. Gutierrez, you understand what's going on now, ma'am?
No, I don't.
All right, you didn't, Mr. DiMaggio, you and your client didn't get an understanding?
You know, Judge, it might be best to appoint another attorney on this case.
Well, what's going on?
It was a simple matter of I was just trying to tell you that the last ticket and the last officer that just got on the screen, that wasn't the same ticket that I've been on a docket for. That's all I was trying to tell you. That is a separate matter.
Gutierrez, I see why you have a problem.
How do I have a problem? Because I'm just telling you that that's not the right ticket.
Because you're not listening. You're telling me what you're on the docket for. I tell you what you're on the docket for.
Okay, so I was confused because I'm obviously on the docket for something new. I haven't been coming to court. I just got that ticket like 2 weeks ago. I didn't schedule a court date for that with Mr. Fitzgerald. He just pulled me over. I know what's going on. It's 3 different tickets going on and it's a lot of charges, but that last one, that's what I have not been coming to you for that. Like, that's something totally separate. That's all I'm literally trying to tell you. I know the ticket that I got from Mr. Fitzgerald, but that is not what I've been coming to you for. I just got that 2 weeks ago.
The SP 6797801. You got that ticket 2 weeks ago, February 11, 2025. Okay.
Right. That's all.
Yeah, we're back on the record with Ms. Gutierrez. Yeah, okay. So that's not even the most important ticket. The most important ticket you do know about, don't you?
Yes, I do. The two.
So what's going on? Why can't you come to a resolution with this individual?
No, I did. I did.
Stop talking. Mr. DiMaggio, I can kind of see why you can't come to a resolution. Or are you driving, ma'am?
No.
I can see why you can't come to a resolution, but what is, without disclosing your client's confidential information, why can't you work this out for her?
Could I see Mr. Bowman? I've been trying to get him. Mr. Bowman. Yes.
All right, let's pass it again. Mr. DiMaggio.
Yes. Yes.
Yeah, why can't have we come to this some sort of meeting of the minds or anything about this?
No, I've gone graciously to Mr. Bowman, and he's explained the offer again. I've explained it to her. She just won't accept the offer. She just says she wants a new attorney, so there's nothing more I can do for her.
Ms. Gutierrez, you just don't understand how this works. I don't know how to explain it to you any better. You don't have the right to come in here and pick and choose which attorney that you get. The only way that you get that right is if you hire one yourself, or you go to this is a case where you requested an appointed attorney and we got you an appointed attorney. And I don't understand what's blocking the movement of this case. I can kind of see it's you. So why can't you speak with Mr. DiMaggio and get some kind of understanding about what's going on?
I tried to, and everybody is getting upset with me because I'm asking questions. Like, I keep just being told to do stuff, and I'm not. This last time I just came back into the breakout room with him, the deal has completely changed and it's something completely different. Everything keep changing. I don't understand what's going on. And y'all kind of just want me to say okay and just do it. So I guess whatever charges y'all have, just okay. And whatever it is. It's okay. I'll do it because I don't want to keep arguing and be combative.
Stop. What question do you have?
I don't have any question. Whatever plea is available, I would take.
Mr. DiMaggio, you know something, Ms. Gutierrez, you're a very, I can respect the fact that you you're serious about this and you want to defend yourself. That's what you have the opportunity to do today. All right. Now, when you mentioned that the other tickets that you had were tickets that were for 2 weeks ago, a little more than 2 weeks ago now, but I know what you mean by that, a month ago. The way I do it is instead of having you come back and forth to court, I told you on that date, I gave you the case numbers, that those tickets will be subsumed in this court hearing today. Now, as it relates to those tickets are an expired plate and a no insurance misdemeanor. Not the most serious charges that we see, and not the most serious charges that you have listed here. I think a more serious charge would be the leaving the scene or failure report accident, which is a 0-point offense. It doesn't abstract to the Secretary of State. It's just going to be a fine. Well, whatever you plead to will be a fine. But leaving the scene of a property damage accident is the most serious allegation that you have here. And then you have some no insurance charges here. So if you're taking into context the 2 cases that you got last month, those cases are basically going to be subsumed in any offer that you get today.
Okay.
The ones that are the more serious ones that you knew that were going to be on the docket today was the leaving the scene of a property damage accident and the failure report accident and the other no insurance charge. And then you had maybe the other cases are going to be dismissed because the officer wasn't here. Now, what is the final offer that you got for Ms. Gutierrez, Mr. DiMaggio? I've said all that, and now he's gone. Mr. Dupree. Failure to report an accident does not abstract to the Secretary of State, does it? Mr. Fitzgerald Harris, Officer Fitzgerald Harris.
Yeah, I'm not for sure, Your Honor.
Ms. Gutierrez, if you do it again, I'm just getting fed up with you. Leave your camera on, leave your mic open.
Okay, I just wrote you. Jesus, I didn't know.
Failure to report an accident, I do not believe in abstracts. So I'm not going to fine you for everything. I'll fine you for one of the matters of $240 and $145. I won't fine you for the second misdemeanor. You want to take the deal, ma'am? Neither of the misdemeanors abstract to the Secretary of State. Neither carry points. I'll dismiss the misdemeanors upon payment. You want to take the deal?
So what you said?
Failure to display. That's a misdemeanor. It's a $240 fine. I will dismiss upon payment. That does not abstract to the Secretary of State, and that does not. Okay, Mr. Bowman.
Do you mean improper plate? Because failure to display is abstractable.
Yeah, I'm sorry. Improper plates. I'm sorry. Improper plates for the no insurance misdemeanor. It's for one of the no insurance misdemeanors. Is improper plate $240 fine. It will not abstract to the Secretary of State, therefore it won't carry any points, and it'll be dismissed if you pay it. And then a civil infraction of expired plates, $145. That does not abstract to the Secretary of State, nor does that carry any points, and that will be closed out once you pay it. I won't fine you for the failure to report an accident. Now, we'll just close that out. If you take the plea. You want to do that, ma'am, or no?
That's fine. Yes.
Have Mr. DiMaggio, have you read Ms. Gutierrez, her advice or rights?
I think I could do it right now if you want me to, Judge. It's been a confused busy day.
Ms. Gutierrez, can you raise your right hand, please? Do you solemnly swear or affirm to tell the truth, whole truth, and nothing but the truth?
Yes.
Or you can put your hand down. Do you understand the maximum possible penalty for this offense is 93 days in jail and or $500 in fines?
Yes.
Do you understand that you have an absolute right to a trial?
Yes.
Let me go over the advice and rights. Let me go over the advice and rights. Give me an advice and rights, please. Do you understand that if you need special accommodations to use the court because of disabilities, or if you require a foreign language interpreter to help you fully participate in court proceedings, please contact the court immediately to make a request. You have been brought to court on a misdemeanor charge. You have the following basic rights. You have to plead guilty or not guilty, or to stand mute. If you stand mute, a plea of not guilty will be entered. You may plead no contest with the permission of the court. To have a trial by jury, to have the assistance of an attorney. Number 3, you have the right to an attorney appointed at public expense if you are indigent, without money to hire an attorney. And if the offense charge requires a minimum jail sentence, or the court determines that it might sentence you to jail. 4, you may have to repay the expense of the court-appointed attorney. In this case, you do not. If you have a trial, you have the following right: to call witnesses to speak on for you at trial. You may get an order signed by the court to require witnesses to come to court, to see, hear, and question all witnesses against you at trial, to be a witness for yourself or to remain silent. If you choose not to be a witness on your own behalf, the prosecuting official may not comment on your refusal to testify. To be presumed innocent unless proven guilty beyond a reasonable doubt. Number 6, if you plead guilty or no contest and your plea is accepted, You will not have a trial of any kind and will give up the rights listed in items 3 through 5 above. 7, you have the right to be released on bond. 8, if you are now on probation or parole and you enter a plea of guilty or no contest, or a finding of guilt is made by a judge or jury, it may result in a violation of your parole, probation or parole. Number 9, you can be sentenced to jail and fines plus costs. The court will tell you on the record the name of the offense, the mandatory minimum jail sentence, if any, and the maximum possible penalty, including jail fines for both. In this case, the maximum possible penalty is 93 days in jail and or $500 in fines. 10, fines, costs, and other financial obligations imposed by the court must be paid at the time of the assessment, except when the court allows otherwise for good cause shown. If you are not able to pay due to financial hardship, contact the court immediately to request a payment alternative. 11, an appeal to circuit court may be taken within 21 days from the date of sentence as permitted, pursuant to MCR 6.625(b). If the sentence includes incarceration and if you wish to file an appeal but are financially unable to retain an attorney, your court will appoint a lawyer to represent you on appeal if the request for a lawyer is made within 14 days after sentencing. 12, federal law and or state law may prohibit you from possessing or purchasing ammunition or a firearm, including a rifle, pistol, or revolver. If you are convicted of a misdemeanor crime of violence and you are a current or former spouse, parent, or guardian of the victim, you share a child in common with the victim. You are or were cohabitating with the victim as a spouse, parent, or guardian, or you are or were involved with the victim in another similar relationship. Do you understand those rights, Ms. Gutierrez?
Yes, I do. I just had one more question. That last case that just came up where the officer got on, he told me that I would be able to show, if I show proof of insurance, and the plates weren't expired, I would be able to get that dismissed. That's still not possible to do because I asked my lawyer that, and he.
Do you have proof of insurance and the plates, ma'am?
Yes.
Show the court proof of insurance and the plates, please.
I don't have it on. I can't bring it up there and show you. How would I show you that right now?
You just hold it up. If you have a copy of the insurance.
I don't have it offhand, but could I bring it up to the court by maybe say this week and then?
We got to do this. Possible? Mr. Bowman, any objection for her to bring this proof of insurance and stuff to the
I could bring it Thursday if that's possible.
Yes, Your Honor, because I was getting ready to state for the record, while you're reading her advice of rights, she's in whatever car she's in.
I'm sitting in the car.
Say Ms. Gutierrez. Listen, Ms. Gutierrez, you gotta let him speak. And then you speak, okay? You're gonna get your time.
Okay.
Thank you, Your Honor. While she's been sitting in this car, while you are reading her rights, she has been playing with her phone and unbraiding her hair. So whether or not you spoke those words of it to her rights, based upon the fact that she continued to do all those things, I don't know whether or not she understood or not what you diligently read. That's number one.
Mr. Bowman, I don't care if she's braiding her hair or what she's doing. I read her rights. She indicated she understood those rights. That's the most paramount thing for the court. My question to you is, will you allow her to bring in proper documentation?
I will not allow her to bring it in. All she's done today is show total disrespect for you and the court system. So she gets no break.
Mr. DiMaggio. Where's Mr. DiMaggio?
And as a matter of fact, Your Honor, if there is another court appearance, I'd like her to be present.
Well, she said there was another court appearance. She said she was gonna bring the paperwork down.
Yeah, okay.
All right. Listen, the attorney's gone. I don't know what's happening, you know. I'm gonna allow you to bring the paperwork in, man. Officer Harris?
Yes, Your
Officer Harris, I'm gonna allow her to bring the paperwork in.
Okay, Your Honor.
Even though I will kind of agree, Ms. Gutierrez, you do kind of exhibit a lack of disrespect. I feel that is not done intentionally because of your passion about the process and things like that. But nevertheless, there's got to be some order here. I think I've given you ample time to speak. But when somebody else is speaking, and when I'm giving somebody else time to speak, it's your time to listen. And I'll give you an opportunity to respond. You can't just jump in and cut people off. You have to take a minute and listen to what they're saying, all right?
Okay.
Including me. When
I just want to say I've been dealing with you for months. I was not trying to be disrespectful to you. I literally was just confused and was trying to get the accurate information because of what was going on. That's all.
There's a way to go about doing that.
I understand, Your Honor. I really do, but I just was confused. That's all. And I'm trying to make sure that my ducks is in a row and that I'm getting the accurate information because to be honest with you still right now, I'm a little bit confused, but everybody is coming down on me because I keep asking questions and keep like, so what are we moving forward? I'm just making sure. Hopefully you don't get too upset. You're dismissing the first case. I know. The two with the insurance and the plates. I'm able to, for both of those cases, I am able to bring my plates and bring the insurance in. I know I have to physically come in with that information and I'm good after that.
No, you still complete something because you got a failure report an accident.
I thought that's what you just said you were dismissing. That's why I'm confused.
Yes, I don't know how much I can. I don't know how much I can tell you.
And honestly, I guess this is where me and my lawyer confusion came in at. I said that I would not have a problem with pleading guilty to those charges for the no insurance and the plates. But that hit and run accident, they're saying whatever is going on, I don't know. I told you that I do not know what is going on. They didn't give me a discovery packet. They didn't give me no information. They just want me to plead to this case, and that is not me. That's all. That is the most important. The most important case that you're talking about. I'm trying to tell you that's not me, and I did not do that. I don't know.
Okay, so we have to have a trial then. She says
that's fine. That's what I wanted to do initially.
She says that's not her. Listen, I'm gonna do this. I'm gonna put Mr. DiMaggio, you guys, to be off the case. I'm gonna let you off the case. We'll put Mr. Dupree on the case.
Okay.
Thank you, Judge.
All right, Mr. DiMaggio, best of luck to you. I'll see you soon.
All right, thanks, Judge.
All right.
Judge, if we could throw Ms. Gutierrez in a breakout room so I can talk to her, but can we, I've got 2 cases ready, I think.
All right, Ms. Gutierrez, I'm gonna go just wait in breakout room 5.